We understand that not only Mr. Kohli's family, but also many members of the public would have been shocked at what would objectively seem to them to be a lenient sentence of 7 years. However, the sentencing of children and young people for serious offences such as this is a complex and delicate exercise. It must be carried out in accordance with received and informed expert opinion as embedded within the Sentencing Council overarching guideline, sentencing children and young people. Specifically, the judge must bear in mind that, quotes, children and young people are not fully developed and they have not attained full maturity. As such, this can impact on their decision-making and risk-taking behaviour. It is important to consider the extent to which the child or young person has been acting impulsively and whether their conduct has been affected by inexperience, emotional volatility, or negative influences. They may not fully appreciate the effect their actions can have on other people and may not be capable of fully understanding the distress and pain they cause to the victims of their crimes. Children and young people are also likely to be susceptible to peer pressure and other external influences, end quotes. See Guideline 1.5. We consider that the judge conscientiously executed the necessary sentencing exercise and conveyed his reasoning to the offender and co-defendant with great skill. We do not find that the sentence imposed was unduly lenient. We dismiss His Majesty's Solicitor General's application. We now turn to the application for permission to appeal against sentence. We make the obvious point at the outset. The guideline on sentencing children and young people does provide that when sentencing children or young people, a court must have regard to the principal aim of the youth justice system, which is to prevent offending by children and young people, and the welfare of the child or young person concerned. However, these principles do not undermine the fact that the sentence should reflect the seriousness of the offence. This was a very serious offence. As we have indicated, we find no error in the judge's assessment that culpability was high. We are not persuaded that the judge wrongly identified or analysed those aggravating factors which he listed. His sentencing remarks display a conspicuously fair assessment of all the circumstances. There was evidence that demonstrated the significant physical suffering caused to Mr. Kohli by the attack. The judge described him as in agony. The offender could not have known that Mr. Kohli was osteoporotic and in 2017 had suffered a wedge compression fracture requiring surgical intervention, making him far more at risk of further spinal injury. But it would have been obvious to him that Mr. Kohli was vulnerable, and we observed particularly so following the second push to the ground, after which the offender kicked him to the body and caused 3 fractured ribs. The use of the balaclava was obviously intimidating and intended to conceal identity, and whether done for the first, less injurious attack does not diminish this aspect of planning. The judge tempered his assessment of the use of the shoe as a weapon being used to humiliate rather than to cause physical harm, but that the offender was the prime participant in the attack and assumed the mantle willingly. As we have indicated, we are not persuaded that the judge disregarded the relevant guidelines principles of sentencing young people. There was evidence that this offender's maturity was commensurate with his chronological age. The judge recognised that the offender's behaviour probably had been affected by, quotes, emotional volatility, end quotes, in his upbringing and possible, quotes, negative influences, end quotes, of his peer, as indicated in the guideline to which we have referred. The judge's approach was individualistic, see Guideline 4.30. The sentences imposed reflected the vagaries of the offender's youth and previous life experiences and was reduced to 1/2 of that which would have been appropriate to an adult. Guideline 6.46. The judge's assessment of the offender's racially offensive reference to Mr. Kohli's ethnicity was nothing but measured. That he assessed this to increase the sentence by an extra 6 months does not render the sentence manifestly excessive. The sentence was a very significant sentence, and necessarily so. It was entirely warranted by and commensurate with the seriousness of the offence. It is simply unarguable that the sentence was manifestly excessive or wrong in principle. We therefore also refuse the application for permission to appeal.